Otherwise, good luck on your arguments today, and we should be in session straight up at 9 o'clock.
All rise. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court. Now sit.
Please be seated. Good morning. We welcome all of you to the Kansas Supreme Court, both those of you who are in the courtroom as well as those who are watching us through our live stream. We have several people in the courtroom today. I understand those include some KU law students who are working their way through Justice Wall's appellate advocacy class. So we welcome you, and not to put any pressure on the attorneys, but they're watching. So welcome to you and welcome to everyone. We're glad to have you all here. I will ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the 9 a.m. docket.
Thank you, Your Honor. May it please the court. First case on the 9 a.m. docket for Tuesday, September 10th, 2024 is appeal number 125936, State of Kansas versus Robert Lee Harris Jr., Johnson County. Briefs both sides.
May it please the court, Michael Whalen on behalf of the appellant, Robert Lee Harris, present and ready for argument.
May it please the court, plaintiff appellee of the state of Kansas by Assistant District Attorney Kendall Kaut were present and ready for argument.
Second case, appeal number 124495, State of Kansas versus Micah Thille, appellant, Saline County. Briefs both sides.
May it please the court, I'm Ryan Edinger, Assistant Appellate Defender, appearing on behalf of defendant appellant Micah Thille, present and ready for argument.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers, present.
Your Honor, that concludes our 9 a.m. docket.
Thank you, Mr. Shima. I want to start by thanking counsel, especially in our second case, who were flexible enough just in the last few days to change the schedule a little bit, as we had what is an unusual event in this court of a last minute removal of a case from the docket by voluntary dismissal of the appellant. So thank you for making that change for us. And it's good to see counsel, a couple of you who haven't seen for a while. So very good to see you back in our courtroom. And with that, if the attorneys in the first case 125936 would like to settle in, and then I'll continue to make some remarks as you do that. And then once we're finished, you can come to the podium. The remarks I would make are just for the audience who may not be familiar with the process and the procedures that we follow. And I would explain that when we receive a case on the docket, we receive briefs from the parties, and then we also have research memos that are done in-house. The court has reviewed those matters. We've reviewed portions or all of the record as necessary to prepare us for the argument. We have we'll be using this time to really explore questions that we have with the attorneys, which may mean we interrupt them at times as we ask questions of them. They usually are quite gracious with that, and we appreciate that because that dialogue helps us get a better understanding of the arguments that they are making. We do have notes. Many of us have them on our computer, some on paper. We will at times be consulting those. And again, just so you know that when we're looking at those, we are focused on the substance of what we're hearing. We are still listening when we do that. So with that, Mr. Whalen, if you were ready to please come forward.
May it please the court, Michael Whalen on behalf of the appellant Robert Lee Harris. A communication is testimonial if it requires an individual to disclose the content of their mind. It's from the United States Supreme Court case Doe versus United States, 487 US 201, 1988. Going to be going through a couple different issues here. Mainly, we're looking at whether or not the passcode is a testimonial statement and something that therefore should be afforded Fifth Amendment protections. We'll also be looking at the specifics related to the revelation of the passcode by Mr. Harris to law enforcement and whether or not that was compelled or coerced, or if his Miranda time had run out of space.
Can I just interrupt in the order in which you said it? So if, the Fifth Amendment protection would be, if it was compelled and if it was incriminating and if it was testimonial in nature. So if we address the first part, the compelled and the voluntariness, does it matter whether or not it's testimonial based on the United States Supreme Court case that says that if a Miranda warning is not given, and even if it was testimonial, that if it was voluntarily made, then the fruits of whatever the information you got, if it was voluntary, it comes in.
I believe that's a correct statement.
So would you mind starting with the voluntariness part? Or would that?
No, that's fine. I'm more than
Right.
happy to.
Can I interrupt you for just a minute? Because
Yes, please.
although I said I would be actively listening, I may have missed if you asked for rebuttal time.
Oh, I apologize, Your Honor. I would ask for 5 minutes.
Okay, let's
With your
let's
permission.
make that adjustment if we can, Mr. Shima. Thank you.
Thank you. It's been a while since I've been here. I
Oh,
apologize.
no, I thought perhaps it was the one that had missed that, so.
Whether or not the statement was voluntary, as related to the passcode. The facts are that Mr. Harris was taken into custody, and placed in an interrogation room on, I believe the 8th in the evening. He was then, questioned by, law enforcement for about an hour and a half. He invoked his right to remain silent. He then was interrogated for another 50 minutes to.
Just to set this up correctly, you're not suggesting that by knocking on the door, there's a problem with that's a continuation of his waiver of the Miranda in that initial interview, that you're not contesting any procedural difficulty with that, is that?
No, Justice Rosen, I'm just trying
Okay.
to.
Timeline. Okay, exactly. I wanted to clarify that that's not on the table.
No, sir.
The only kind of Miranda question that's on the table is whether he should have been re-Mirandized the next day.
Yes, Your Honor.
Okay, thank you. That's fine.
Then it's unknown as to when he was how much longer he stayed in that interrogation room at the Tomahawk Ridge Center and was then taken to the jail. Approximately 3 o'clock in the afternoon on the following day, after about 17 hours since he was taken into custody, Mr. Harris was approached by Detective Melvin and another detective. And he was not given any Miranda. And in fact, Detective Melvin testified that he didn't even know that whether or not Mr. Harris had been given his Miranda rights or warnings previously. And we're not questioning whether or not the Miranda rights were given the day before. But when we look at the totality of the circumstances as it relates to whether or not he needed to be re-Mirandized, we have.
What did you just say? I'm sorry.
Whether he needed to be re-Mirandized or Mirandized again before speaking with Detective Melvin.
But let's just assume, for purposes of your argument, that he needed to be, just assume that he needed to be re-Mirandized. And so he wasn't. Or even assume that he was never Mirandized. I'm just wanting to focus on the voluntariness. And I think that, we recently had a case come out, I don't know if you're familiar with it, In Re GO, which talked about, that you look at the totality of the circumstances and whether the person's will was overborne, and that you look at the details relating to the actual interrogation, and then those relating to the characteristics of the accused. And that's what we look at for voluntariness. So even if there was a Miranda violation, I just want to get to the heart of the voluntariness, because if it was voluntary, it doesn't matter whether he was Mirandized, right?
Well, I think I would disagree, because if we make the argument that it is testimonial in nature, that he should have had the protections before revealing information that could potentially incriminate him, or giving access to the phone information. If we get past the Miranda issue, then we're looking at, he was in custody for at least 17 hours. There was no evidence put on by the state as to what his mental state was, whether he was sleepy, if he was in a good mental state. He was approached in an interview room in the jail. We don't know whether or not he was handcuffed or not. Detective Melvin testified he did not remember whether or not Mr. Harris was shackled or handcuffed at the time. It was then put to him, we have a warrant for your phone, give us the passcodes. And Mr. Harris, said, is this something I need an attorney for? And I said, well, that's for you to decide. And then went to him and said, look, here's the deal. You can give it to us now, or we can go and get a court order and force you to do this. And then they also said, we're going to get it from you one way or the other. And that's where we're saying the coercion, the compelling statements came in by law enforcement saying, you don't have a choice in this matter. We're getting this information, so give it to us now.
How is that different from someone from an interrogator saying that we are gonna, they don't have a warrant, and the person says you can't search my car, and they said, well, you can either give us permission or we're gonna go get a warrant.
I would argue that that is coercive in its presentation. And here, I think it goes a step beyond, we'll just go get an order from a judge. First of all, there's no precedent that sits there that's saying that a court can compel somebody to give their passcodes, because that issue has not yet been decided in Kansas. So he wasn't standing on known precedent.
Doesn't that cut against your argument? I mean, I think taking us back to GEO, there's two components to our test. You have to demonstrate police overreaching. And you're suggesting the statement that we're going to get it one way or the other. I could see if our court had clearly held that no, passwords are testimonial, cannot be compelled. That maybe is an argument for police overreaching. But when it's an undecided issue, doesn't that cut against you?
No, I don't believe that it does, Justice Wall. Just because it was an overreach for the officer to say, I can go get this court order and force you to do it, because it was unknown. And it was not at that time, there was no precedent or basis for him to be able to make that assertion.
Well, hadn't he already done it in a different case?
Well,
This particular officer had in fact gotten orders from a court ordering people to give passcodes, correct?
yes, he had stated that he had done it once before, but he had did not know of any other officer that had done it.
So doesn't that cut against your argument that he thought he was telling the truth and he had something to back it up, which was a court order in another case?
He had that belief, but it was not based upon any legally accepted parameters. It was not something that had ever been challenged before in the courts. And so I would say that for him, he's just making a statement, although he may have done it in the past, but there was not a legal basis for him to make such a claim.
But the exclusionary rule is meant to be punishment for inappropriate law enforcement behavior. It's a judge-made law that is made as a deterrent to law enforcement. Quit it. Stop doing this. So how can we justify that judge-made law to exclude obviously relevant probative evidence because he based his decision on what he understood judges did legally.
Well, I don't know that we can say that the passcode is important, knowledgeable information. The information from the phone, the police definitely wanted. But the passcode itself was a product of Mr. Harris' mental efforts.
Quite possibly just a shortcut.
Yes, ma'am.
We have two doctrines at play here, the good faith doctrine that the state relies on in arguing that the officer actually had good faith to make the statement. And then the requirement or the threshold test of was there official coercion? Are those the same or is there territory between those two concepts? And are we following within those? Somewhere in that gap between those two concepts, or are we falling in one or the other of those pockets of doctrines?
I think we have with the I think they cover, they in a Venn diagram, I think there would be some crossover there. But with the good faith exception, I think that does require to be some actual legal background that they were relying upon for that good faith. And I think that's what's missing here, is that this was a question that had not been addressed. And despite his prior experience with one judge, he did not have that legal basis to stand upon.
You were saying that the coercion was two things, one way or another, or we are going to get it anyway. And then you're saying we are going to get it anyway. There was no legal basis for that, right? That's your argument?
No,
Because it's not set
to say that
law.
I think to say that I'm going to go get a court order and make you give me this passcode is what there was no legal basis.
Fine. But on the one way or another, are you alleging that that was implying any kind of physical violence or?
No.
Okay.
No, it's just that as the statement, we're going to get it from you one way or the other is coercive within its statement.
What's your best case to show coercion? I mean, I'm kind of looking at your brief and I'm kind of having trouble aligning the arguments you're making with a particular case law support. What do you think is your best case?
Off the top of my head, Justice Biles, I don't have one to give you.
If I could real quick take you back to where you started, which is the testimonial nature of the passcode itself.
Yes, Justice.
You didn't really get a chance to flesh that out. Why is it testimonial? I mean, it seems to me the argument could be put at least that it's utterly irrelevant to any of the facts that might be required to either prove the case or disprove it.
Well, the information that's contained within the phone itself.
Sure, but that's not what we're talking about. We're talking about the passcode.
Right. We're talking about access to that information.
Access is different. I mean, that's my question. What makes that testimonial? So for example, if I could give you a hypothetical, cops show up to a house and it's a secure house. It's well locked up. They knock on the door and say, "Open up, we have a warrant." Is the person inside compelled to comply with the warrant's order to have the house searched?
No. I mean,
And then
say no, but then.
Right. So then the cops say, "Look, you got a nice front door. We really don't want to mess it up. We really like you to open the door, but if you don't, we're going to smash it down." And then the person inside is like, "Well, okay, fine." Is that testimonial? It's not testimonial, is it?
It is because it's a cogent creation of the individual's mind. It is something that they have developed and put into play.
So if the front door is keyed by voice control, saying open sesame. That's testimonial? Is that your argument? As opposed to simply turning the deadbolt?
If there were an actual, if the voice activated required a passcode,
Well,
such as open sesame.
Why isn't a voice print? It's its own passcode. I mean,
Well, if the voice print, I think we run into a differentiation here potentially between a thumbprint.
well, let's say it's voice to stick as close as possible to. I mean, it sounds to me like your argument is yes, if the door only opens to the voice printed command of the owner, then that's testimonial. That sounds to me like your argument.
I think there's a distinction to be made as to whether or not there's an actual phrase that was created by the person and not just a voice print. If it's just, open door, that could still be.
But if it's a secret phrase, then it is.
Right. It would be based upon the same kind of passcode, something created by that individual in order to gain passage to the house. And there's obviously a split in most state and federal cases as to whether or not it's testimonial or not. If there are no other questions. Thank you, Your Honors.
Counsel?
May it please the court, plaintiff appellee, the state of Kansas by Assistant District Attorney Kendall Kaut. Justice Stanridge is certainly correct that there are three things required for this statement to be suppressed without getting into the good faith exception, inevitable discovery, and potentially the foregone conclusion, whether it's incriminating, compelled, and testimonial. And I at least will start with voluntary, and I know there are a variety of questions and directions this can go, so happy to address anything that this court may want to discuss with me. But the statement ultimately is voluntary in this setting because he has already been Mirandized. He knocks on the door in that first interview. When the detective comes back that next day, he's been given the Miranda within a reasonable time frame.
I don't want to derail you too much, but are you conceding that for the evidence not to be suppressed, the disclosure of the passcode has to be voluntary?
I am not, Justice
Okay,
Stegall.
it sounded like you were just a second ago, so I may have misheard you.
My apologies, Justice Stegall, for not being clear on that point. We are not. I think all three of those components would have to be met.
In other words, if it's not testimonial, it can be compelled.
It can,
It's a
Justice
legal
Stegall.
Process.
Exactly. The only way it maybe couldn't is if there was some due process claim.
I mean, they can't beat it out of him, but a court could order it.
Exactly right, Justice Stegall, under our perspective on this case. Yes. And so we believe it is voluntary, given the nature of that interaction. We quote that Maddox case, which lists a variety of cases, including more than one day is appropriate to come back and not have to re-Mirandize somebody. I also think looking at the totality of the circumstances of that interaction, it's important to note when Mr. Harris says, "Do I need a lawyer?" the officers let him know that's up to him. And in the opinion that Justice Foth writes out in the order he has for this case, he notes that the officers reacting and telling him that would be his decision shows that Mr. Harris is aware he could consult with an attorney before making the decision. He's been Mirandized and previously invoked his rights. And we know this man works at a cancer center at St. Luke's Hospital. So he's not somebody overwhelmed by the police in this instance when he reveals the passcode to them. On top of that, I think in this instance, what's also important to note is that the court could just decide this and once again sidestep the testimonial nature, the foregone conclusion doctrine, whether the good faith exception applies, and sidestep it. Certainly before getting into this issue and briefing it and arguing an oral argument, was not aware of how truly complex this could be, but I think this court was correct when it said in State versus Lemmy back in 2020, this court need not plow this ground and whether it supports the existence of error today, because, as the state argues, any possible violation of Lemmy's Fifth Amendment right in this case was undoubtedly harmless. And so that would be one issue I'd like to just discuss briefly, because I think that could also come up as a way to sidestep things. But certainly, I don't want to forego any questions about, is this testimonial or not? Was it voluntary? Does the good faith exception apply? Certainly willing to answer any of those questions as well.
So I'd like to give you a hypothetical. And that hypothetical is that someone is arrested and the Miranda rights are starting to be read, and the defendant interrupted, saying, I know my Miranda rights. And so law enforcement asks him about a gun, and the defendant says, well, I'll tell you where the gun is. And then law enforcement goes and finds the gun. They seek to enter it into evidence because it's incriminating evidence. And the defendant says, you need to exclude the gun because it was found as a result of un-Mirandized statements in violation of my Fifth Amendment right to self-incrimination. What is that? Should it be suppressed?
Justice Stanridge, I think in that instance where they have not fully read the Miranda rights, you would once again look at the totality of the circumstances, the good faith exception. I think the U.S. Supreme Court may have addressed some of these issues in the past as well. I think in that instance, there'd be a colorable suppression claim. You'd have to look at everything there. But I think that'd be obviously different than this case, given they read him his Miranda rights, he knew them. But I think in that case, there's a possible suppression issue. But I think it's different than our case, given in this instance, Justice Stanridge, he was read Miranda, he'd invoked before, and then Mr. Harris personally knocked on the door and re-engaged, showing a far greater instance of the officers from Overland Park in this case actually reading Miranda rights, giving him that option, and honoring him when he did invoke and not coming back until he knocked on the door. So I think that's the difference, but I agree in that circumstance, it could indeed be different.
Well, the United States Supreme Court disagreed with you. Those are the exact facts of U.S. versus Pantane from 2004, and said the physical evidence, the gun, did not need to be excluded, even though it was found as a result of an un-Mirandized statement, because the Miranda rule is meant to protect against self-incriminating statements, not necessarily to exclude physical evidence derived from that. So, does that change your position knowing what the Supreme Court said?
Sure. So Justice Stanridge, yes, it would change my position and that was the case I was thinking of, but wasn't exactly 100% on, so didn't want to say definitively in my research for this. I think that was like a 5-4 decision from the middle of the 2000s, if not mistaken.
So how is what happened here different from that?
I think the difference here is they actually honored the Miranda rights the first time.
Let's say they didn't. I want to focus on this. I don't understand how the Miranda, when we look at voluntariness and you look at all the totality of the circumstances and you're looking at, the details of the interrogation, number 8, because there's, 9 kind of things, a non-exclusive list. Number 8 is involuntariness, whether the accused was informed of the right to counsel and the right against self-incrimination. So I can see where, that comes in under voluntariness when you're looking at the totality of the circumstances. Otherwise, I don't really understand, given this Pantane case, I don't know how to pronounce it, but why it matters.
It may not have to matter, Justice Stanridge, and I think given what you've mentioned with that case, the court doesn't have to get there. I think if it does, though, given those differences I've outlined, that would be enough as well.
Is there a presumption the statement is involuntary if they're not Mirandized and they're in custody?
Justice Wilson, I don't believe there has to be that presumption. However, if they're in custody and they're not Mirandized, it could be a custodial interrogation. In that instance, then you'd get to that framework where if it is a custodial interrogation, then we go to, is it testimonial? So it may or may not matter depending on, I think, the facts once again. I'd also would like to address again that we think this is harmless regardless. Mr. Todd at trial, and I think this is very important, conceded this is an intentional homicide. So all the jury had to decide upon from listening to the arguments of counsel, is this intentional murder or is it premeditated first-degree murder? And so as a result, with the evidence that came out, that's how it, I think, should all be framed on these questions about whether the passcode being testimonial or not mattered and what evidence came out from the phone.
Wait,
Wasn't that
I thought all the most of the premeditation evidence came from the phone, didn't it?
Justice Rosen, there's excellent evidence of premeditation on the phone, but I don't believe that's the exclusive evidence of premeditation.
What else was there? I mean, just the searches alone, I think, satisfies the premeditation element. But what else is there besides what was garnered from the phone? Just observations of the neighbors, that kind of, and his behavior, or what? What else is there?
Justice Rosen, exclusively the phone could have convicted him. I agree with that statement. What else we have in this case are several things. First, the testimony of the doctor who did the autopsy mentioned that Tanisha Harris had to die by strangulation. And he said the nature of a death by strangulation with petechiae, with the nature of her having blood coming out of her head from being hit by that glass object that was on the counter, means this would be a several-minute homicide. And that the nature of that shows that this is someone who's very angry, who might have planning to go through and kill someone at such a long length, and that it's not an argument. On top of that, you have evidence in this case that Ms. Harris went home over her lunch hour. Her boss and someone from HR at the bank she works at mentions that Ms. Harris only had a 30-minute lunch break she could take, and that she never was an employee who took longer than that lunch break. But we know she went home for lunch that day because she doesn't return and she's left her badge at her workstation, which would imply she comes home for some reason and then never returns from lunch, which would mean her husband would want to get her home from lunch, and that would show planning by her husband to bring her there in the first place. The texts are helpful in that instance, but even without the text, there would be plenty of evidence for premeditation. And then his actions afterwards of covering up the murder by placing her in trash bags, by driving her car near where his boyfriend lived, by dumping her in Missouri, would all be evidence of somebody that didn't just get in a fight and have an intentional crime, but is somebody trying to cover up his tracks. So those three things would show beyond a reasonable doubt why this would be harmless, Justice Rosen. If there are no additional questions, I would yield my time, but I know with the complexity of this issue, there may be some others on testimonial, foregone conclusion, and I'd certainly be willing to answer any of those questions.
Well, is it the state's position that this is not testimonial?
Justice Stiegel, you're correct.
Can you just summarize your argument briefly?
I will certainly attempt to, given the complexity of it, Justice Stiegel. Our argument there would be in line with the Southern District of New York, that there is a distinction between the passcode itself and the contents of the phone. So revealing a passcode would be more analogous, as you asked, Justice Stiegel, to voice commands or handwriting, that it's just a quick 6-digit number, and it's the contents of the phone itself that would be testimonial, and there's a distinction there. So the Southern District has agreed with that kind of line of thought, in contrast to some other courts that have said, well, that is the content of the mind directly. We're just going to say that's a literal statement and go there. So that'd be one part of our argument. The second part of our argument would be that foregone conclusion doctrine, that because Mr. Harris is on his phone, that the state or any government could establish that is indeed his phone. And we know there would be some messaging on the phone since he's looking into it. And under the foregone conclusion doctrine, then the state would be able to get access to it. And that would be based on those two U.S. Supreme Court cases. Certainly, that's a very complex doctrine. Different courts disagree on it. I don't think the Kansas Supreme Court has ever addressed that from my review of looking at Westlaw and what I've been able to find. But that would be a secondary argument to the testimonial nature of the phone as well.
Because you could subpoena the cell provider and get that data through the carrier. Is that the inevitable discovery? Is that the argument? You're not suggesting that it's inevitable because it could be compelled, because that argument depends on it, whether or not it's testimonial, right?
We are not suggesting that, Justice Wall. I think the argument here would be the foregone conclusion doctrine should be read to say, if you know files exist and have some basis for it, then a government agency, whether the state here or the federal government trying to get tax documents from an accountant in that original case could do it, but not necessarily the phone carrier, although that could be one argument for another.
What is the basis then? I guess that's what I'm trying to understand.
Sure. Justice Wall, the basis is simply if a governing agency knows the documents exist, they would then have a right to get them under the foregone conclusion doctrine for the passcode. That would be the basis that I've been able to surmise for how that doctrine would apply.
In this exact case, didn't the government have the right to obtain the information in the phone? There was a warrant, right?
Justice Stiegel, a warrant had been issued before by Judge Welch.
And given that, does it matter for the testimonial, not testimonial legal question? Does it matter factually whether or not the government could have forced and broken down the front door, in other words?
Justice Stiegel, we think it does not, because ultimately we think the state could have gone back and gotten that second warrant. Judge Foth didn't issue one for the passcode or an order for the passcode, but given there was a warrant for the contents of it.
I guess what I'm asking is, does it matter if the government had the capability of breaking the lock on the phone?
it could matter, Justice Stiegel, as another alternative to saying that could be inevitably discovered. And that gets into the Cellbrite data. We quoted from that New York Times story that said 6-digit iPhone passcodes can normally be broken in about 11 hours. And that gets into algorithms can figure out that if you have certain digits, they're more likely.
Right,
to be
but what I know all that, but what I'm trying to figure out is whether that fact matters legally. In other words, if this was a super technologically proficient person who essentially had an unbreakable code on their phone, would that matter as to the question, the legal question of is it testimonial or not?
Justice Stiegel, that question would not matter, testimonial or not. I think that gets into inevitable discovery and how the court would want to view breaking into the phone. I think testimonial or not just relates to, is a passcode a small blip that gives you access to it more akin to a key, as opposed to, is the passcode testimonial or not? So I think it's a prerequisite question to whether you get to inevitable discovery and the breaking into the phone.
Okay.
And how you come down on that question.
Ask about the foregone conclusion because that is very complicated. And I want to make sure that I understand your argument. What you're saying is in this case, applying SCOTUS, that that the law enforcement had reason to believe, I guess, that he would be searching for ways to kill his wife without, because that's was the premeditation that they had reason to believe that would be on his phone.
And Chief Justice Lukert, I see my time is about up. May I have time to answer that question?
Yes.
Thank you, Your Honor. Justice Stanridge, I don't think the foregone conclusion doctrine is that narrow to say they knew he'd have searches about trash bags or things like that. It would simply say, because he has a cell phone, because the police see him on it at the time they're near him, there'd be some messages about his activity that day.
Why did they see?
Because I think it relates to the nature of cell phones, that people use them, they communicate, he's on the phone. So there could be some messages on there about his activities that day. And as we mentioned in our brief, it could be exculpatory evidence too, to show, hey, I never was at Walmart or I never was in these spots. I was just at home all day. I couldn't have moved the body. If she's not here, that exculpates me too.
What is the standard of proof for foregone conclusion? Is it reasonable suspicion or probable cause or what?
Justice Stanridge, I don't believe there's a standard for the police have to believe or not. I think it's that the government agency has to show there is a basis to believe documents or something exists related to a case. And I think because there are only those two U.S. Supreme Court decisions, and the last one is, I think now a quarter century old, we don't have a lot of guidance on it. And so that's why certainly if it gets to testimonial communication, then the foregone conclusion doctrine, without harmlessness, without inevitable discovery, we're certainly in a very complicated world of trying to figure out exactly what the contours of it mean.
Thank you.
Thank you. And if there are no additional questions, Chief Justice Lukert and Your Honors, we would simply ask this court to affirm the judgment of the jury and ultimately affirm the judgment of Judge Foth. Thank you.
Thank you. Mr. Whalen, you reserve 5 minutes.
I just want to touch on a couple of issues that came up with counsel. I would agree, Justice Stiegel, that there was very little evidence of premeditation outside of the phone itself. Even the nature of the suffocation, the coroner testified that it could have occurred by him from somebody sitting on her chest and restricting her ability to breathe, which was what Mr. Harris's statement was to law enforcement. So we don't have any other preparations, and his statement to police was this was something that came up out of a fight between the two of them that got violent. They wrestled and she attacked him with a vase and some other issues. So I think that is something that would be missing. The foregone conclusion doctrine, I read it the same way I believe that you do, Justice Standridge, in that the state has to have some knowledge of what information is contained in the documents that they're trying to, that they're saying it's a foregone conclusion, we'll get these. As long as he admits that they're his, we know what they are, we can get them, because that was the situation with the tax documents that they got from the accountant. So I would say that I don't believe the foregone conclusion argument applies necessarily in this matter as it relates to those issues. those were the main issues that I wanted to address, and unless the court has other questions, I would yield the rest of my rebuttal time.
I see no questions. Thank you.
Thank you, Your Honors.
Thank you to both counsel for your arguments this morning. The court will take this matter under advisement. Might just briefly explain what I mean by that, and that is that later today, the court will conference this case, and we will make some preliminary decisions, including assigning the case to a justice for drafting an opinion. That justice will share their draft of the opinion with the other 6 members of the court. And there will be back and forth. Sometimes there will be people who write separate opinions. There could be multiple separate opinions before the case is resolved. That process will go on until the court is comfortable with the decision or decisions that have been written. And then we release and file our decisions routinely, usually, and almost always, but with an occasional exception, on Friday mornings. There will be a press release that announces the decision, as well as the decision being posted on the kscourts.org website, soon to become kscourts.gov website. That's available. And one thing that sets the judicial system apart from other branches of government is the way in which our decisions are set out in a form that people can follow and understand the rationale and the process of how we reach the decision that we make. And you would be able to read that decision and hopefully at the conclusion of that, understand why we reached the conclusion we did. So with that explanation, thank you, counsel, again for your arguments. I will now call 495, State of Kansas versus Micah Thille.
May it please the court, I'm Ryan Ettinger, Assistant Appellate Defender, appearing on behalf of Micah Thille. With the court's permission, I'd like to request 3 minutes for rebuttal, please.
3 minutes is reserved. Thank you.
Thank you. A Sedgwick County jury in this case convicted my client, Mr. Thille, of a single count of reckless second-degree murder. Importantly, the jury also acquitted Mr. Thille of felony first-degree murder, second-degree intentional murder, and first-degree attempted murder. The issue that I brought before this court in our petition for review as a follow-up to our appellate brief is that the Court of Appeals erred in affirming the district court's denial of a requested lesser included offense instruction for voluntary manslaughter. Of course, this court knows that voluntary manslaughter is a intentional killing done in 1 of 2 ways statutorily, either upon a sudden quarrel, the heat of passion, or upon an unreasonable but honest belief that circumstances existed requiring the use of lethal force. What I've argued here and what I want to argue before the court this morning is that the facts in this case were sufficient to satisfy both of those components, either form of that offense of voluntary manslaughter. The facts in this case were that my client, along with several other people, approached this. We're searching for my client's brother, Max Thille, who had disappeared with apparently his girlfriend or partner's bag. And he had gone to this residence well known as a drug house. This house is full of people that are all, for the most part, what we can tell is they're all consuming methamphetamines and heroin. Max is in this residence. My client gets a call that Max has gone to this house. He's sort of hiding out there. And my client, Mr. Thille, along with a couple other people, including the person whose bag had been taken, Valerie Vogel, and somebody who's known as One Hit, as well as my client Max, and then Max's girlfriend. My client Micah and his girlfriend Kayla. So they go to this house, and here's where this case is very difficult because every single witness in this case has some sort of different recollection, and I would say vastly different in some regards of what exactly happened at that time. And that's why I think everything at this point really became a question for the jury to sort out exactly what was going on here. Who's credible, who's to be believed in this situation as far as what happened. There was testimony that there's yelling at the front door. There's testimony that Micah went to the front door to ask, where is Max? I guess Valerie was screaming something about, I want my bag back. So there's there's a confrontation either at the front door, on the porch. There's even some question about whether these people were in, like, not necessarily Mr. Willingham, the victim in this case, but the other participants in this incident, whether they were even on the porch, whether they were standing in the yard. So the argument is that when these facts are viewed in the light most favorable to my client Micah, that there was sufficient evidence here to convict of that lesser included offense of voluntary manslaughter. And I think furthermore, there's testimony that the victim in this case, Mr. Willingham, was the first person to shoot a weapon. Now, what I took issue with the Court of Appeals opinion was this sort of idea where the court sort of listed some of these facts and then says, well, distilling it down, Thille seemingly views Willingham's act of reaching for his hip during their quarrel as sufficient provocation to warrant a voluntary manslaughter instruction. Well, I would argue that is really distilling it down. So it's to the extent that it's almost ignoring all of the other evidence at trial. Yes, my client did testify, and I would even argue that it is pretty much sufficient. It is sufficient to warrant that instruction because there was clear evidence that what he was reaching for, even though Micah said, I never saw the weapon, it's very reasonable and would have been a reasonable inference for the jury to make the inference that he was reaching for a gun. So, and subsequently, Winnie Hogan, who was another witness, said that when she attended the dead body of Mr. Willingham, the gun that he had had in his holster was no longer there. So there's a holster on his hip on the deceased body. It's clear that he's reaching for the gun. So
Are you relating these facts to the heat of passion instruction or to the imperfect self-defense instruction, or both?
I think they apply to both.
Let me try to break it down a little bit. I can understand the argument as to why they apply to the heat of passion,
Okay.
but under the requested I'll call it imperfect self-defense instruction. Isn't there a subjective element to that lesser included?
Yes, I believe there would be.
And was there any subjective testimony was there any testimony about the subjective intent or state of mind of
Micah?
Is it Thille?
Yes, Thille. Yes, sir. Yes, Your Honor. I think there is some testimony to that.
He didn't testify about it, did he?
He said that I didn't know he was reaching for his hip. And then he said that at that point I pushed him.
Didn't he testify that he did not shoot him?
He did say that he did not shoot them. He did not shoot him.
So how could there be any evidence that he did, from Thille himself, that he did shoot him out of this subjective belief?
I don't think there even has to be evidence from just because there's other evidence.
Well, the evidence has to go to his subjective state of mind. And if he's saying, I didn't even shoot him, how could he ever have provided evidence of his subjective state of mind for why he shot him?
I'm unsure how he would have subjectively, but I suppose from an objective standpoint of the subjective question, that there's other testimony that the jury could have relied on. Clearly, the jury found.
Do you think it's possible to prove a subjective state of mind from circumstantial evidence?
I would say in this case that would be the argument. Yeah, that we have that here.
So the jury can infer from other evidence his subjective state of mind?
In this case, I would say that is a fair assessment. Yes. I suppose the other issue that I needed to cover today was the
What
question.
about, what about his conduct? I'm not so sure about the other witnesses providing credible evidence of a subjective state of mind of somebody else, but does his conduct help you at all when we're focusing on the imperfect self-defense? Is there anything about his behavior that gives us some indication or upon which a reasonable juror could infer where his mind was at through the progression of this incident?
And I think that's what I'm driving at, Justice Wall, is that his conduct, everybody said the conduct was such that there's no indication that my client was necessarily it was yelling or screaming at him. I want to see Max. I want to get the bag back. At that point, the conduct from Mr. Willingham is to reach for his hip. And another witness said they heard him say something like, "What the hell?" So I think at that point, it can be inferred that he's at that point, making a show of force against my client. At that point, my client is going to be thinking, I need to defend myself. These are circumstances that I believe, honestly, in my subjective mind, that I need to use lethal force. Furthermore, there was evidence that when my client, Mr. Thille, pushed him away when he went to reach for that hip, at that point, there were shots fired. And there's testimony that the shots were fired at Micah and his girlfriend, Kayla, and that there were, Max also said that he saw, that he witnessed Mr. Willingham fire 2 shots. So from those facts, I think that it's pretty clear that even though Micah said on trial, I didn't shoot him. I mean, that's an inconsistent defense, but I don't think there's a problem with that. So because I think there is a lot of other evidence where we can say, look, he clearly, the conduct of Mr. Willingham would have caused Micah to have that subjective belief.
So you're saying the jury could have simply not believed Micah when he said,
Precisely.
I wasn't there.
Clearly they didn't. They did that in this case because they convicted him.
And was that belief unreasonable? Does it have to be?
I'm sorry, Justice.
I mean,
Is what?
he may have held the belief. It sounds like you're making an argument for perfect self-defense, whereas the instruction would require that belief to be unreasonable.
Well, I suppose
How are you threading that?
It's hard to sort of divide this is because of the inconsistencies in everybody's testimony. So I guess there's 2 different ways here of what happened. I suppose it's not reasonable if he's only going to say, pull out his gun and say, please leave or something. It is then, on his mind, subjectively reasonable to act with lethal force if he's pulled the gun out and is shooting at him. So I think there's 2 different. Do you understand? Does that answer your question, Judge Stoll?
I think so.
Okay.
Well, it's a sufficiency question, isn't it? If you give the voluntary manslaughter instruction and the jury says, yes, I believe there was an unreasonable but honest belief, then our review would be, is there sufficient evidence to support that?
Correct.
So we would have to decide then whether his belief was unreasonable or if there's evidence to support an unreasonable belief.
Right. And I would say that the evidence to support an unreasonable belief would just be the simple, as the Court of Appeals pointed out, or distilled down, was the only relevant or salient fact was that he was reaching for his hip. Just the reach for the hip would then be unreasonable. But I would like to, I mean, I really think that does apply in this instance, but the real more important, I guess, forceful component is the sudden quarrel, which is really what I focused on in the brief, and this fact that there is a immediate and sudden quarrel here when those 2 have this confrontation, either on the doorstep, just inside the doorway, or even in the house. And that's also a big question that this big issue in this case is there's really so much differing testimony that it's really hard for the court to hang its hat on something and say, no, I'm going to deny that instruction because this is what happened.
As I read the Court of Appeals opinion there, they went back to saying, but it doesn't qualify as a sudden quarrel because this was a very foreseeable altercation when Thille and his companions show up in the middle of the night. At least the sorry, I'm drawing a blank on the woman who was with him, his name, but she was agitated. She wanted her stuff back. They
Right,
were
right.
demanding, they wanted to see Max.
Right.
They were, they were aggressive and agitated at that point. And so can you address that part, why they were wrong in that and
Thank you for that opportunity, Justice Lickert. I do want to address that. In that instance, so this idea of foreseeability, an unforeseen action being the nature of a sudden quarrel to sufficiently be of the legal provocation. I think that goes and ties in with this idea of it can't be some protracted thing. And I know the court cited State v. Lowry, which I didn't really think had any really bearing on this case because that was somebody that was being restrained, attempted to flee from like an attempted murder situation. And the defendant tried to argue that when they left, and that was a sudden quarrel. And so it's only voluntary manslaughter. So I think really the focus here is whether or not it's some sort of protracted thing. And foreseeable to the extent on some level, I don't see it being foreseeable that this would occur as far as I'm going to get a gun drawn on me. Micah didn't make any threats, that nobody testified to him saying, I'm here to beat you senseless if you don't, whatever, turn over my brother if you don't give us this property back. He essentially just now, other people were agitated, correct? But there was really no evidence that Micah went to the door screaming at anybody other than just, hey, where's my brother? I want to talk to my brother. And at that point, Mr. Willingham reaches for a pistol. So I don't see this as being any sort of, there's no prior beef. In fact, my client said he didn't even know that Mr. Willingham lived there. So that's why I think this does fall into the category we submit of a sudden quarrel with legal provocation.
And your reliance on the harmless argument is that the no reasonable probability, the error affected the outcome in light most favorable in the entire record, but is basically what the jury did here.
Right, Justice.
That they rejected.
They rejected everything basically, but the least serious offense. And my argument there, which the Court of Appeals didn't address that either. They just said there's sufficient evidence of reckless conduct. So we're not going to find that being harm. That's not error. My argument is, yeah, but look at what the jury did in this case. They rejected, and that's the other thing, that there's this idea of they gave alternative accounts for felony murder, burglary. I want to say it was burglary, which required a forceful entry. The jury rejected that. So the jury rejected all of these more serious offenses, landed on the least serious offense that they could find, somebody culpable for Mr. Willingham's death. And I would argue strenuously that that's exactly what the jury would have done in this case if they'd been given, properly instructed on both voluntary manslaughter and involuntary manslaughter as well.
They would have gone even lower.
Exactly. Exactly. Based on the nature, and the Court of Appeals even recognized that in its opinion when it said that the involuntary manslaughter instruction should have been given due to the nature of everybody's differing accounts, the wide discrepancies in what actually happened, and the fact that all these people, almost all the witnesses, I mean, there's no testimony about Mr. Thille, but clearly everybody in the house, all of those witnesses were using drugs. So that's going to affect their perception, their credibility. And I think the jury at this point is throwing their hands up and saying, well, somebody's culpable here, but we're going to take the least possible serious conviction. Unless there's other questions, I'd yield the meeting. Thank you.
Okay, thank you. Ms. Chalmers?
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. I guess I'll start with voluntary and then move on to involuntary. As the state's position that essentially there was not sufficient evidence of sudden quarrel, a reasonable provocation that would allow someone to use self-defense. If this court is to say that you can break in essentially uninvited to someone's home at 3:30 in the morning and bring along 3 other people, scream and yell, push somebody, and then get to shoot them, that is incredibly dangerous precedent for basically anyone who ever wants to defend their home, because now I guess it's a free-for-all for all invaders.
Well, they're still criminally culpable, right? It's just a different offense that they're asking for.
They're still criminally culpable, but not nearly as much. I just don't think that any of the case law on heat of passion or reasonable provocation that this court has ever said, if you are invading someone's home, you can now pretend like you have some kind of justified right.
So
But-
I understand the argument. It seems in tension to me with the standard of review that this court has announced on these questions of sufficiency standard of review, essentially. In your mind, what would happen in this exact case with a little tweak, which is the heat of passion instruction had been given and the jury had returned a guilty verdict on that? And then it gets appealed. What happens on that from your perspective?
Lost cases when the judge has given heat of passion instructions over our objection, not in this exact scenario, but for say, when someone shot a law enforcement officer that was chasing them, lost that case at the Court of Appeals. This court didn't take review of it. Based on insufficient evidence, we've lost at least two.
In other words, the evidence was too sufficient.
It was.
I mean, that's the tension of our standard of review, is it not? How does the state lose a case because they had too much evidence?
Well, no, the state lost that case because the Court of Appeals found there was insufficient evidence for heat of passion. They flipped the conviction and we just walked, no conviction at all.
I know, that's what I'm saying. How is that possible? I mean, I don't know what case you're referring to, but it sounds to me like you're saying that you lost a conviction entirely.
Yes.
Because the Court of Appeals said for
The
the
judge
lesser included, there was insufficient evidence.
Yes, and that happens with heat of passion most frequently because there has to be an objective, reasonable provocation.
But you had sufficient evidence for the higher charge.
Yes, because
So
it was
just help me understand, like how is that?
the district court judge screwed up and gave an instruction that was unsupported by the evidence, and then the Court of Appeals said that lesser was unsupported by the evidence. As how it happened. I mean, you don't shoot law enforcement.
Yeah, well, that highlights to me the tension that I was trying to draw attention
Right, and so because I think a lot of district courts, because this court has made such an easy standard to get.
So if I could summarize what you're saying, you tell me if this is correct. You're saying that it is in fact possible, because of this court's standard of review on these things, for the state to lose because they had too much evidence.
Oh, you mean we proved more than the lesser?
Correct.
Yes, because we
Or
absolutely.
at least you didn't prove it because you didn't get the conviction, but there was sufficient evidence for the.
Yes, the jury.
Had the
made
jury
a
convicted,
compromise verdict. We had too much evidence that we could have gone on the higher.
Okay.
But isn't that the function of a jury, is to assess that evidence? If it's sufficient to support your more severe charge, but also the lesser included, isn't that part, I mean, that's just our jury trial system, right?
That is, the only problem that hits typically is, and I actually go around and teach CLEs where I tell prosecutors to oppose heat of passion. It's the only instruction I say depose, because we lose convictions, because then the Court of Appeals, I don't think this court has granted review in any yet. The Court of Appeals turns around and says there was actually not sufficient evidence.
It strikes me that in the heat of passion context, appellate courts have made a pragmatic choice to construe sufficiency of the evidence as a legal question. Do you agree with that?
That is a legal question on whether or not it's, because it's an objective standard on whether or not there's an objectively reasonable.
In other words, they don't ask, could a reasonable juror have concluded, that they say, is it even legally possible?
Yes,
And that's this case, right?
yes. And I'm saying
The
no.
Court of
it's not.
Appeals said that it was not legally possible.
Correct.
Based on foreseeability, or are you suggesting based on the actual, or both, the actual way the incident unfolded and the foreseeability of it?
All the facts here, yes, both the way the event unfolded, the foreseeability, and then.
Is there
as
a
Justice
tension?
Siegel, sorry.
Oh, I'm sorry, but I'll go ahead. Is there some tension? So we are in the factual appropriateness prong.
No, I think
Correct.
you're in the legal appropriate.
Well, it is legally appropriate, isn't it? I mean, it's a lesser,
But it's still a legal stand.
but we are in the factual, I mean, that's my point. Is we're in the factually appropriate prong, but we have a legal analysis that essentially says, as a matter of law,
It's not factually appropriate. Yeah.
it's, as a matter of law, it's not factually appropriate.
Yeah. So
Does that
it
make
seems like
sense?
We slid over to the legal part.
Well, I don't know. I'm just
But
asking
that's,
for,
yeah, to me, since it's still a legal question, maybe the actual error is that it was. but it is still based on the facts though, but still, it's basically kind of like a summary judgment in any other case where you can prove all these facts, but you have no legal claim because those facts don't meet the legal standard. But what I was actually going to spin around and say is based on your earlier point, which was my response to the cross petition, the defendant here said he did not fire the shots. He has to have an unreasonable but honest belief. There is no evidence that he honestly believed that he was ever in danger. So I think that is the.
But aren't you, I think there's some conflation going on here between the self-defense and then the
Oh, you're right, I
sudden
switched.
quarrel, heat of passion. And I even think at the beginning you said that you know, when you made your introductory statement that you can just go into someone's home and, you know, based on self-defense. But if the core elements of whether the, you know, the factual appropriateness of voluntary manslaughter are an intentional killing, okay, and a legally, and this is objective, legally sufficient provocation. So it must deprive a reasonable person of self-control and cause that person to act out of passion rather than reason. So give me your best argument why the facts here don't establish that.
He broke into someone's home at 3:30 in the morning to.
Okay, it was on the doorstep at first, right? We're
Right.
on the doorstep.
He pushes in.
Well-
Again, 3:30 in the morning, he brings basically an angry mob to this person's house uninvited.
Well, so, but, okay, so this is your argument. Okay, go ahead.
I mean, that he does. He brings an angry mob to this person's house uninvited and then shoots him twice.
Okay,
I-
but how are you showing that it wasn't acting out of passion? He just got so upset. I mean, is it your belief that this was premeditated?
I think the state charged that, but the jury went with reckless second. So I'm going in reckless second land. I'm not saying that the premeditation or not matters. I'm saying that you don't get to break into someone's home, enter their home, and then say, it's an objective, not subjective standard. I objectively have the right then to shoot this person who is trying to take some action potentially to defend themselves.
Right, but now that's where you're conflating the self-defense. Because when you're just talking about voluntary manslaughter, there is no self-defense. I mean, this is just, I went crazy. I wanted to see my brother. I went crazy. And, you know, and it was just, you're not letting me see my brother, you know, and so I shot him.
That is not a sudden quarrel, though. A sudden quarrel, and I think actually, Your Honor, with respect, you're conflating the two. The sudden quarrel has an objective standard. There has to be sufficient provocation. There wasn't here.
I'm not going to let you see your brother. Get off my doorstep.
That is not, if we can now shoot people because you're denied entry into a home, that is incredibly.
Well, we're not allowing people to shoot people. We're trying to see the difference between whether something was reckless or whether somebody just the heat of passion.
And again, that's an objective standard. It is not objectively reasonable to say.
Okay, so that's your bottom line.
Yes.
Not objectively reasonable to get out of control and passionate because you can't see your brother who stole something from your sister-in-law.
You have to have legally sufficient provocation, and that just simply does not exist here.
Well, what about somebody shooting shots at you? And if we're viewing the evidence in the light most favorable to the requesting party, don't we have to consider the testimony that the victim fired the shots? And if some in the direction of the defendant? And if that is true, if I have the record correct, is that legally sufficient provocation?
I simply agree with the Court of Appeals that no, not here, not under this facts. Not when you come into a house. It is reasonable to assume someone's going to defend themselves when you invade their home at 3:30 in the morning. I don't think we want to say that anyone can now say, well, I am going to invade someone's home. If the homeowner tries to defend themselves, I now have the ability to shoot them and I won't get premeditated murder or felony murder or anything like that. I can now get, felony murder actually.
Why doesn't that go against what you're saying? It's not reasonable. Isn't the fact that, you know, is reasonable part of this? Well, we're looking at to be legally sufficient, it must deprive a reasonable person of self-control and cause them to act out of passion.
Well, to me, reasonable is an objective standard. And yes, you have typically, I don't actually know of any case that the court has ever found heat of passion. It is one that you consistently say there is not sufficient evidence for.
Well,
The sufficient evidence is usually the textbook law school case is you caught your significant other in bed with another person, you lose control, shoot them immediately. If you have any time to think it over, typically this court has said, no, not heat of passion.
okay, but if someone shoots in your direction, and we're not talking about anything to do with self-defense. Okay, let's not conflate that, keep that over there. But just someone shoots in your direction and you just get out of control and just
I don't
lose your,
think you're out of control at that point. Actually, I think that's
Really?
a rational reaction to being shot at is to maybe return fire.
Is one of the elements the jury has to decide is whether there is an objectively reasonable situation.
Right.
So aren't you really asking us to reweigh the evidence? Because you don't think it's objectively reasonable.
I think a reasonable person doesn't think it's objectively reasonable. And if you're
So
anytime
you're
the word-
reasonable, but the jury is not.
The jury didn't do anything here. So I'm not fighting a jury verdict.
But you're saying there is no objectively reasonable situation, and I'm afraid I'm going to lose if I give that instruction. So I don't want the jury to be able to decide that,
I'm saying that
because they might be wrong.
if the jury comes back and says yes, that this court or the Court of Appeals will vacate that conviction because there is not sufficient evidence. Because an objective standard is something, this court, you're all objective people, you get to make that decision. It doesn't involve reweighing evidence. It's a legal standard at that
The
point.
exact Court of Appeals panel that heard this case would have vacated that conviction.
Yes.
That's
They would have
exactly what they
vacated-
said, correct?
Yes, they would have vacated the conviction if we had given that. And that's why we fight these, is because we will lose potentially everything.
But it's
Um,
also
Is
a
that right?
situation.
I mean, the Court of Appeal said they would, is that the correct result here? I mean, I guess are you asking us to revisit our long line of cases, which some took exception to regarding 22, 34, 14, and what reasonably justify a conviction means? And we've applied over the last 10 years,
Especially the evidence
yeah,
standard.
what are you asking us to do? Is that what you're asking us to do?
I think this was correctly decided under the current standard. Would I like you to revisit that? Yes. Did I brief that though? No. I think that Your Honor, in your cases where you've dissented or done concurring opinions where you've said that standard is not the right standard and we could go back to before that standard, I would love that, but that's
No,
not what I
forget that.
briefed.
That's long, yeah, but so you're not asking us to do that. You're asking us to apply the standard and it doesn't.
Yes, I'm saying that apply the standard the way it's been applied for the last 10 years.
You're saying
The
that
end result-
viewed in it, sorry, go ahead.
The end result of that, though, would you agree, gets to some of the questions you were taking from the other side of the bench, which is that in fact, it takes the reasonableness question away from the jury. It's exactly what it does in this case, right?
It does, but it's because it's a legally objective standard. And
I
so
understand, but isn't that driven by our standard of review? In other
it
words,
still has the
this-
sufficiency of the evidence standard.
right, we have a sufficiency standard which drives the question of whether this is a question of law or a question of fact. And because we want to avoid the circumstance that you've described, we treat the reasonableness question as a question of law.
Yes.
We have as flips of how we look at the evidence, one of those two tests. In terms of looking at the instructional issue, we look at in the light most favorable to the defendant, is there evidence to support it? But when we look at the sufficiency, we would look at it in the light most favorable to the state. Does that cause the collision of results potentially here that we're struggling with? Where it might be appropriate to give the instruction to the jury, but then it might not meet the sufficiency standard?
It should across the board made the sufficiency, because if it's in the light most favorable for the defendant and he somehow gets that, it should also be in the light most favorable to the state.
That's what I would think. So why, I guess I'm trying to figure out how we get the inconsistent results.
I think because it,
Or
well-
the results that seem to be in tension. Maybe.
Right,
Not inconsistent.
I still am of the opinion that in the cases where the Court of Appeals flipped those convictions, the district court is the one that messed up, not the Court of Appeals. Because the district court found there was sufficient evidence for a jury instruction, there was never sufficient evidence for. But here though, I think
Because the evidence has to meet a legal threshold in
Yeah.
order to sustain the conviction. And that's your argument, is that even viewing the evidence in a light most favorable to the defense, it just doesn't cross that threshold that they have to get across the legal threshold of adequate provocation. And maybe foreseeability is a separate doctrine. I don't know, or if that feeds into the same standard.
exactly, Your Honor. And not sure if I should transition now but even if the instruction should have been given, I do think harmlessness comes into play here too, because again, the defendant said, I didn't shoot him. There's no suggestion that he did so because there was this quarrel involved, or I absolutely can't figure out how that he would be able to get an unreasonable but honest belief. So even if you're convinced in the light most favorable defendant, the actual evidence here would make any error harmless.
This is a little unusual in that we do have that statement from the defendant, but obviously the jury didn't believe the defendant.
Yes.
So given those circumstances, can we just set that aside and just then look at the totality of the evidence to see whether or not he would be entitled to it as we look at the facts and the other people's testimony?
I think you can for the sudden quarrel. Like that's pretty easy to do, look at the facts. My problem with doing so when there is such a subjective, like imperfect self-defense, voluntary manslaughter is entirely subjective. You basically knocked out the objective prong and it's subjective. And he has to have an unreasonable but honest belief. I don't know how you get into whether a defendant honestly believes anything without a defendant saying this was my honest belief. So I do not think there's sufficient evidence of an honest belief here of any kind. And if in fact he suddenly has the right now to shoot back when someone is trying to defend himself, I don't see how that's unreasonable either. So I do not think that legally he can get unreasonable but honest, but if somehow this court disagrees, I would say no reasonable jury would get there. On the reckless one, I realized I cross-petitioned. Oh, I'm sorry, do you want me to talk about that?
Yeah, I'll go ahead if you would. I think we're interested in that and we've asked several questions. So.
On the reckless one, I realized I cross-petitioned and then didn't brief how much I am not a avid fan of the standard of review. So that was probably some mistakes that I made. But I don't know how essentially there are facts supporting mere recklessness. Here, if in the light most favorable to the defendant to get recklessness, he's essentially firing a firearm in close proximity, either an inch to 3 feet away from a person twice. And to me, that's just recklessly under circumstances manifesting extreme indifference to the value of human life. So
The problem I'm having with this whole discussion, is if the case is as you portray it, he would have he would have gotten a better conviction, but they did not convict on those other crimes. And so they've rejected that. And given that, I'm having a hard time figuring out why I get to go back into those facts and use them against the defendant in this context. And it applies to the this other issue as well. This jury just, from your perspective, went off the rails.
I mean, anytime you fire a gun and hit someone, at minimum, you have reckless, but
It went off the rails, and And, you know, and so that's the trouble. You know, it'd be so easy to say, well, he said he didn't shoot him. So all of that should go out the window, except they didn't buy it.
They did found he didn't shoot him, or that he did in fact shoot. So we know, the fact we know is the jury found that he killed him and that he didn't do so intentionally, essentially. In the reckless involuntary versus reckless second degree murder, we are in clear error standard. So now the defendant gets to have the burden to prove that the jury would have convicted of the lesser reckless. And it's my position that a reasonable jury would not do that here because he fired 2 shots in close proximity. That's not just recklessness. That is extreme. Extreme indifference to the value of human life. And I don't think I have anything else to add.
I have one more question, and I know you probably can't do this off the top of your head, but I am very curious to know the name and site of the case that you were talking about with the Court of Appeals.
Yeah, can I provide a 609 letter? Would that be okay? Or
That's fine.
That would, yes,
Okay.
you may.
Oh,
Do you-
sorry.
And
no,
then
yeah.
Not in charge of that.
Treasurer will have an opportunity to respond. If
Okay.
you-
I'll just cite the case with no argument if that's okay. All right, thank you so much. The state would press the earphone.
Mr. Edgar?
I think I just wanted to touch briefly on one point that you made, Justice Stiegel, about this sort of inherent tension that we have when we're doing this analysis of, okay, we think it's a clean divide between legally appropriate, factually appropriate, and then how once we're into the factually appropriate, we're starting to talk about legal principles. Well, that's exactly what the jury's for. They're instructed to take the facts that are in evidence, apply the law that's given to them.
Yeah, I'm sympathetic to your argument that the way we do this arguably takes the reasonableness question away from the jury.
Right, so that's
Is that essentially what you're?
essentially, yeah, that's the function of the jury, and that's the point of making this case, is that there was so much different evidence and so many different versions of this story that this is the perfect case where the if it's a legally appropriate instruction, we're going to give it to the jury and let them sort it out.
I'm glad you brought that. That sort of is the last hanging chad, if you will, at least in my thinking on this case, which is the Court of Appeals definitely treated this as a factual appropriateness question. In fact, they just kind of gloss over legally appropriate by saying, well, if it's a lesser included, it's legally appropriate.
Correct.
Is that true in our case law? In other words, when you have a lesser included that has an added element, have we always said it's legally appropriate, or do we have to analyze that added element?
And which added element?
Well, the added element of a legally sufficient
Legally
provocation.
sufficient provocation.
I mean, I'm not for sure. That's why I'm asking the question. I think some of our older case law treats that question as a legal question and analyzes it under the legal appropriateness prong.
Your Honor, I honestly, I can't say that I have a,
Would that make sense? If you don't know, that's fine.
I don't know.
Would that make sense to you?
I mean, it could make sense, yes, to be fair, yes. So I don't know if the court has any additional questions for me. I guess one other thing I want to touch on too with you, Justice Stanridge, was this idea of just, okay, yeah, and that's the argument I made, this is a sudden quarrel. I didn't have any prior beef with this. My client didn't have any prior beef with this guy. There's no ongoing thing. It just found out that his brother is in this place. He's also the same place that my brother keeps going to get high. And he's supposed to be in court in the morning. Now, I know a lot of that didn't come out, but I mean, that wasn't ever testified that, hey, I went there because of that. But I think it's something that the jury, and that was part of the entire testimony in the evidence trial. So that also adds to this sudden, he lost control. I think it just makes a lot of sense, and that he didn't, this isn't just I'm barreling through your front door, some home invasion. I went to the front porch, wanting to know where my brother was, wanting to know why you're still selling drugs to my brother. So I think that is a sufficient legal provocation in this case to justify that.
So factually, you're saying that the evidence could justify this scenario that he's there with his group on the porch and he just went in to get his brother. Did he break in? Did he break down the
No,
door?
the testimony again varies. Some
Right,
witnesses
but
say
is there
that,
evidence that he did not break down the door?
yeah, there's plenty of evidence that he didn't break down any door. There's testimony that Mr. Willingham, the victim, came out right away, opened the door and said, "What the hell?" At that point, it seems to be a reasonable inference then that he was then reaching for his hip, like, "I'm just going to go ahead and shoot you right now." There's also testimony from one of the witnesses that said that Micah just, like, the door was open or something and he just walked right in, and Mr. Willingham was poking his head out the door. It's just all over the place, frankly. So it's difficult to even, and that's where I come back again to due to that. And the Court of Appeals even recognized that when they said that I should have given the involuntary manslaughter instruction, that based on all the divergence between the testimonies and what really happened here, we had to just kind of turn this over to the jury and let them sort it out. So that's where I think the error was in this case by the Court of Appeals and the district court. We just asked the court for a reversal, and I think the court for its time this morning.
Thank you. Thank you to both counsel for your arguments in this matter. The court will take this case under advisement. The court is now on recess until 9 a.m. tomorrow.
All right.